On the night of my 21st birthday, my mother stood up in front of 40 guests and told them I would receive 5% of nothing. She smiled when she said it. I did not cry. I did not argue. I set my champagne glass down on the white tablecloth, pushed back my chair, and walked out through the French doors into the cold Newport air. What my family did not know was that a sealed envelope had been sitting in a Boston notary's filing cabinet for 11 years, and the morning of my birthday was the exact date printed on the outside. Their cruelty had just triggered the one clause that would leave them with nothing. My full name is Olivia Ann Harper, and I grew up believing that love inside a wealthy family worked the same way it did everywhere else. It took me a long time to understand that it did not. The Harper estate sat on 4 acres of oceanfront property in Newport, Rhode Island. White shingle siding, black shutters, a wraparound porch that caught the Atlantic wind every afternoon from May through October. From the outside, it looked like the kind of home that appeared on the covers of architectural magazines. From the inside, it ran on a currency I could never quite earn enough of, no matter how hard I tried. My brother Crew was born first. That single fact arranged everything that came after. Crew Harper was 3 years older than me, broad-shouldered, loud in the easy way that confident men are loud, and he had inherited our father's ability to walk into a room and make everyone feel that his arrival was the event they had been waiting for. My parents adored him without reservation. My father, Richard, brought him to the office at Harper and Wren Holdings before Crew could read a balance sheet. My mother, Diane, referred to him in conversation the way people refer to landmarks, as something fixed, essential, and permanent. Crew was the future of the family. Crew was the one who mattered. I understood my role by the time I was 9 years old. I was the second child, the quiet one, the one who read too much and asked too many questions at dinner. When Crew broke something, it was an accident. When I broke something, it was carelessness. When Crew got a B on an exam, my father said boys developed later. When I got straight A's, my mother said I should focus less on academics and more on being present. I learned early that the rules in our house were not the same for both of us. And I learned even earlier that pointing this out accomplished nothing except making the room go cold. My grandfather Gerald was the exception to all of it. Gerald Harper had built Harper and Wren Holdings from a single commercial property in Providence in 1971. By the time I was born, the company owned 11 office complexes across New England and a portfolio of coastal real estate that my father managed with the careful pride of a man who knew he had inherited rather than built. Gerald was in his late 60s when I came along, already semi-retired, spending most of his time at the Newport house while my parents ran the Boston operations. He had white hair and wide hands, and he smelled like cedar and black coffee, and he was the first person in my family who ever asked me what I thought about something, and then waited to hear the actual answer. We used to sit together on the porch on Sunday mornings when I visited. He would read the financial section of the Globe, and I would read whatever novel I had brought, and neither of us felt the need to fill the silence. When I was 14, I told him I wanted to study law. My mother, when I told her the same thing at dinner that night, said that was an interesting hobby. Gerald, the following Christmas, gave me a leather-bound copy of Black's Law Dictionary with my initials stamped on the cover. Inside the front page, in his careful handwriting, he had written, "For the one who pays attention, he died the spring I turned 18, 6 weeks after I graduated high school. I was not allowed to speak at the funeral. My mother said it would be too emotional for me, that Crew would represent the grandchildren." I sat in the third pew in a black dress and held the copy of Black's Law Dictionary in my lap because I had not known what else to bring. And I listened to my brother deliver 4 minutes of remarks he had not written himself, and I did not make a sound. 3 weeks after the funeral, I enrolled at Boston University under a dual program, political science and pre-law. I did this without telling my parents. They assumed I was studying business, which was what they had suggested, and I did not correct them. I paid my own tuition through a small educational trust Gerald had set up for me independently when I was 12. A trust my parents knew existed but had never thought to examine closely because the amount seemed modest and Crew had a larger one. What they did not know was that the trust also contained a note from Gerald's personal attorney referencing a separate document filed with a notary in Boston. I did not find that note until my second year of law school. By then I had transferred to Boston College Law and was working 20 hours a week at a mid-sized firm in the Back Bay under my mother's maiden name, Olivia Wren, Law clerk, later Olivia Wren-esque. My parents' social circle was wide, but it ran in predictable channels: country clubs, charity galas, the same 6 zip codes. No one in that world read the associate listings at a commercial litigation firm. No one looked twice at the name Wren. I kept the two halves of my life completely separate for 3 years. On weekends, when I drove back to Newport for holidays or obligatory dinners, I was Olivia Harper, the quiet daughter who hadn't figured herself out yet, who should really think about settling down, who was lucky her parents kept her name on the family account. On Monday mornings, I was back in Boston in a charcoal blazer, reading deposition transcripts and drafting motions and learning, with increasing precision, exactly how the law handled documents that had been altered, concealed, or destroyed. I was not planning anything. Not yet. I was simply paying attention, the way Gerald had taught me. The note in the trust file mentioned a notary named Margaret Wren. No relation, just a coincidence of names that had made Gerald smile, according to the attorney's memo. Margaret had witnessed and retained a copy of a document Gerald signed in the spring of my 10th birthday. The memo said the document was a testamentary amendment with a conditional trust clause. It said the effective date was tied to a specific birthday. I read that sentence 4 times sitting at my kitchen table in Alston at 11 o'clock on a Tuesday night. Then I closed the file, made a cup of coffee, and sat very still for a long time. I did not call anyone. I did not search the name online. I wrote the notary's office address on a piece of paper, folded it, and put it in the inside pocket of the blazer I wore to work. I kept it there for 7 months, until the week before my 21st birthday, when I finally made the appointment. I needed to know exactly what was in that envelope before my family made their move. As it turned out, I was 4 days too late to stop the announcement. But I was exactly on time for everything that came after. The birthday dinner was my mother's idea, which meant it was orchestrated down to the centerpieces. Diane Harper did not throw casual gatherings. She threw events, controlled environments where every seating arrangement, every floral choice, every pause between courses served a purpose she had decided in advance. The invitations had gone out 6 weeks early, cream cardstock with navy lettering, requesting the presence of 40 guests at the Harper Newport estate for a dinner celebrating Olivia's 21st birthday. When she handed me mine across the kitchen island, she said, "I thought it was time we did something proper for you." I should have heard the word proper more carefully. The guests arrived at 7. I recognized most of them: the Aldrich family from the country club, the Brennans who owned the marina, 2 of my father's oldest business partners and their wives, a handful of Crew's college friends who had never once spoken directly to me, and my mother's book club, which was less about books than about the maintenance of social position among women who had married well and intended to keep it that way. There were also 3 people I did not recognize, seated near the head of the table close to my father. They had the particular stillness of men who are paid to be present at other people's important moments. I found out later they were from the family's law firm. The dinner itself was beautiful, and I remember almost none of it. Lobster bisque, I think. A rack of lamb. White tablecloths that caught the candlelight. The kind of meal that exists not to be eaten but to be witnessed. I sat in the chair assigned to me, not at the head, which was my father's, nor at the immediate right, which was Crew's, but 3 seats down on the left, positioned close enough to the center to appear included, and far enough to signal the actual hierarchy to anyone paying attention. Crew was in good spirits. He had recently been named acting head of the acquisitions division at Harper & Wren, a title my father had created specifically for him, and he wore his new importance the way he wore everything, loudly, and without apparent awareness that anyone else was in the room. He told a story during the soup course about a golf trip to Pebble Beach that took 11 minutes and required no input from anyone else. His girlfriend laughed at everything he said. My father watched him with the specific expression he reserved for Crew: open, warm, uncomplicated. The expression I had spent 21 years trying to produce in him without success. My mother did not eat much. She moved food around her plate and spoke to the guests on either side of her and refilled her water glass 3 times. And I noticed, because I had spent my whole life learning to read her, that she kept glancing at the far end of the table where the 3 men from the law firm sat. She was waiting for something. The plates were cleared after the main course. The servers brought dessert: a birthday cake, 3 tiers, white fondant, my name in gold script across the front, 21 candles. The guests turned toward me and I smiled the smile I had perfected by age 12, the one that looked genuine from a distance. Then my mother stood up. She did not tap her glass. She simply rose, and the room quieted immediately, because rooms always quieted for Diane Harper. She had cultivated that particular authority over 40 years of careful social management, and she wore it as naturally as she wore the single strand of pearls at her throat. I want to take a moment, she said, to speak about the future of this family. I watched her hands. They were perfectly still at her sides. That was how I knew this had been rehearsed many times. She spoke for 4 minutes. I know because I counted. She talked about Gerald's legacy, about the responsibility of stewardship, about what it meant to carry a family name forward with intention and purpose. She talked about Crew, his vision, his dedication, his natural aptitude for leadership. 3 of the guests nodded while she spoke. The men from the law firm did not react at all. Then she said my name. Olivia has always followed her own path, she said. The room was very quiet. We respect that. And in the spirit of honoring both of Gerald's grandchildren, the family has made some thoughtful adjustments to ensure the estate plan reflects the realities of where each of them is today. She paused. Crew will assume primary stewardship of Harper and Wren Holdings, along with the Newport property and the majority of the family trust. Olivia will receive a 5% non-voting interest in the holding company. She said it the way you announce a weather forecast. Measured, informational, final, 5%, non-voting. A number so small it was not a share. It was a gesture. A way of keeping my name attached to something without giving me any actual claim to it. The kind of arrangement that sounds considerate at a dinner party and means nothing in a boardroom. 40 people heard it. 40 people who would go home that night and repeat it to their spouses and their neighbors and their tennis partners, and in every retelling the shape of the story would harden a little more. Olivia Harper was the daughter who got the lesser share, and there must have been a reason for that, because families like the Harpers did not make decisions like this without a reason. I looked at my father while she spoke. He was watching his water glass. I looked at Crew. He was nodding slowly, the way he nodded at things he had already agreed to. I looked at the 3 men from the law firm. One of them had a leather portfolio open on the table in front of him, and I could see the corner of a document clipped inside. The paper was cream-colored, heavy stock, the kind used for formal legal instruments. The cake sat in front of me with 21 candles burning. My mother finished speaking and looked at me with an expression I had seen before, not unkind precisely but resolved. The expression of a woman who has done something she believes is necessary and has already stopped questioning it. The room was waiting. I picked up my champagne glass, took a single sip, and set it down on the white tablecloth with a small clean sound. Then I pushed back my chair, folded my napkin, and placed it beside my plate. "Thank you for the dinner," I said. I walked the length of the table, past the guests who had stopped looking at me, past the servers, standing along the wall, through the French doors at the far end of the dining room, and out onto the porch that faced the ocean. The Atlantic in October was black and cold, and it made a sound against the rocks below the lawn that had nothing to do with dinner parties or family trusts, or the careful cruelties of women who smile while they take things from you. I stood there for a long time. Behind me, through the glass, I heard my mother begin directing the servers to bring more champagne. Inside, someone laughed at something, Crew said. I watched the water, and I breathed the salt air, and I thought about a folded piece of paper in the inside pocket of a blazer hanging in my apartment closet in Boston, and the appointment I had kept 4 days earlier with a notary named Margaret Wren, and the sealed envelope she had handed me across her desk with steady hands and no expression at all. I had not yet opened it. I had wanted to wait until after tonight, because I had not known exactly what tonight would look like, and I had wanted to understand what I was walking into before I decided what to do next. Now I knew. I went back inside, said brief goodbyes to 3 people I actually liked, collected my coat from the front closet, and drove back to Boston alone in the dark. The envelope was on my kitchen table when I got home at midnight. I made coffee. I sat down. I opened it. The envelope contained 11 pages. I know that number precisely because the first thing I did, before I read a single word, was count them. It is what you do when you have spent 3 years learning to read legal documents. You check the pagination, you verify the sequence, you look for gaps. Gerald's original will, the version my parents had filed with the probate court after his death, contained 22 pages. I had pulled a copy from the public record 2 days before my appointment with Margaret, sitting at a terminal in the Suffolk County Courthouse with a notepad and a cup of cold coffee. That version had no page 11. The numbering jumped from 10 to 12, cleanly, as if page 11 had never existed. In a document that dense and carefully formatted, a gap like that did not happen by accident. I had stared at it for a long time in the courthouse, not quite ready to name what I was looking at. Margaret Wren's copy had all 22 pages. Page 11 was a single-paragraph testamentary amendment, witnessed by Margaret and 2 independent signatories on a Wednesday afternoon in April, 14 months before Gerald died. It established a conditional trust in my name, Olivia Ann Harper, funded by 51% of Gerald's voting shares in Harper and Wren Holdings and the deed to the Newport estate. The trust carried one activation condition. It became effective and irrevocable on the date of my 21st birthday. The date printed at the top of page 11 was October 14th. I had turned 21 on October 14th. I sat at my kitchen table until 3 in the morning, reading those 11 pages 4 times through. My coffee went cold. A truck went by outside on the street below and rattled the window in its frame, and I did not look up. I read the language of the trust clause the way I had been trained to read contested language. Slowly, looking for ambiguity, looking for anything that could be argued around. I found none. Gerald had used a careful attorney. The clause was clean, specific, and airtight. When I finally put the pages down, I did not feel triumphant. I want to be honest about that. What I felt, sitting alone in my kitchen at 3 in the morning with 11 pages in front of me, was something closer to grief. Because the document in my hands meant that Gerald had known while he was alive, while he still had time, that something in my family's architecture was wrong enough to require this kind of protection. He had not told me. He had not warned me. He had simply built a wall around me quietly, and then died before he could explain why he thought I would need it. I thought about him on the porch on Sunday mornings, the cedar and coffee smell, the way he handed me that dictionary. For the one who pays attention, he had been paying attention too. For longer than I had known, I put the 11 pages back in the envelope, sealed it, and placed it inside the locked filing drawer I kept under my desk. Then I washed my coffee cup, changed my clothes, and lay down on my bed without sleeping. By 6 in the morning I had made 3 decisions. The first was that I would not contact my parents. Not yet, and not directly. Any communication I initiated before I had secured the legal position would give them time to construct a response, and Richard Harper had been working with the family's attorneys for 30 years. I was 21 years old with a law degree I had kept hidden. I needed to move carefully. The second decision was that I would call Daniel Chu. Daniel was 2 years ahead of me at Boston College Law, now a third-year associate at Hargrove & Associates in the Financial District. We had studied together through 2 brutal exam seasons, and he was the only person at the firm who knew both of my names. He was methodical, unshakable, and he had a particular gift for probate and estates litigation that he was slightly embarrassed about, the way precise people are sometimes embarrassed by their own precision. I trusted him completely, which was a short list. I texted him at 6:12 in the morning. I need 45 minutes. Not at the office. Bring coffee. He replied 4 minutes later. Renders. 8 o'clock. The third decision was that I would do nothing visibly. I would go to work. I would return my mother's call from the night before. She had left a voicemail at 11:30, composed and brief, saying she hoped I had gotten home safely and that she thought the evening had gone well. I would respond to that message in a tone that gave away nothing. I would behave exactly as my family expected me to behave. Quietly, without protest, in the manner of someone who had accepted what she had been given. Deanne Harper had spent 21 years teaching me to be invisible. I had spent 3 years learning to use it. At Renders, Daniel listened without interrupting, while I walked him through the document. I did not give him the original. I had made 2 certified copies the morning after Margaret's appointment and stored them separately. But I had brought 1 copy in a plain manila folder, and I watched his face while he read. Daniel had the professional stillness of someone who had learned not to react visibly to information, but when he reached page 11, his jaw tightened slightly and he set down his coffee cup. He read it twice. Then he looked up. "How long has the page been missing from the filed version?" he asked. "Since the original probate filing," I said. 3 years ago. He was quiet for a moment. Outside on Boylston Street a bus went by. Your father would have been involved in the filing, he said. He handled the entire probate process, I said. He was executor. Daniel folded the copy closed and placed both hands flat on the table. Olivia, he used my real name, not Wren. He only did that when something was serious. You understand what this is. I understand exactly what it is, I said. He nodded once. Then you understand we need to be very careful about the order of operations. That was how it began. Not with a confrontation, not with a phone call to my parents, not with anything loud or visible. It began with two people at a corner table in a coffee shop on a gray October morning, a manila folder between them, and a methodical conversation about sequence. I went home that afternoon and called my mother back. She answered on the second ring, warm and unhurried, as if the previous evening had been an ordinary birthday dinner, and not the careful dismantling of something Gerald had spent years building for me. I just wanted to make sure you were all right, she said. You slipped out so quietly. I was tired, I said. It was a long drive, of course. A pause. Olivia, I hope you understand that the decisions your father and I made came from a place of wanting what was best for the whole family. Crew has real plans for the company. You've always been more independent. I listened to her voice, and I thought about page 11. I understand, I said, and I did. Margaret Wren's office was on the fourth floor of a narrow brick building on Tremont Street, sandwiched between a tax preparer and a notary supply company, the kind of address that existed in every city and was noticed by no one. I had found her through Gerald's personal attorney, a retired man named Callum Briggs, who had moved to coastal Maine after the probate closed and who responded to my letter. I did not email. I wrote a letter, because letters require a decision to open them, with a single typed paragraph confirming that yes, Gerald had engaged an independent notary for a private document in the spring of Gerald's final active year, and that the notary's name and address were on file should the relevant party wish to make contact. He had underlined the words relevant party. I had made the appointment for the Tuesday before my birthday. I told my office I had a dental procedure. I drove to Tremont Street alone, parked 2 blocks away, and walked the rest. Margaret Wren was 71 years old, small and deliberate, with reading glasses on a chain around her neck, and the particular manner of someone who had spent decades being trusted with other people's important moments and had learned to treat that trust as a professional obligation rather than a personal one. Her office was organized with the precision of someone who considered disorder a form of disrespect. Every file had a label. Every label had a date. She did not ask me to prove who I was beyond my identification and bar card. She simply looked at both, set them on the desk in front of her, and said, Gerald told me you would come when it was time. I had not expected that. I kept my face still. He said you would wait until you were ready, she continued, opening a drawer on the left side of her desk. He said you would not come early, and you would not come panicked. He said you paid attention. She placed a sealed envelope on the desk between us. My name was written on the front in Gerald's handwriting. The same careful hand that had written for the one who pays attention inside my dictionary. Below my name, in smaller letters. To be opened after your 21st birthday, or immediately upon any adverse action by the estate. My birthday was in 4 days. My mother had already begun alerting guests to the dinner. I considered the phrase adverse action by the estate and understood that Gerald had anticipated this too, that he had built a secondary trigger into the instructions, a recognition that the people managing his estate might move before I was ready. I'd like to open it now, I said. Margaret nodded as if she had expected that answer. Inside were 2 items. The first was a letter from Gerald, 3 pages, handwritten, dated the same afternoon he had signed page 11. I will not recount all of it here. Some things belong only to the person they were written for. But I will say that by the 3rd page, my hands were not entirely steady, and that Margaret quietly placed a box of tissues on the corner of the desk and said nothing, which was exactly the right thing to do. The second item was a certified copy of page 11, with Margaret's notary seal and the signatures of both independent witnesses intact. But it was what Gerald had written in the letter that changed the shape of everything. He had known, by the last year of his life, that Richard intended to contest or suppress the amendment. He did not know exactly how. Richard was careful, and Gerald was aging, and there were limits to what he could track from Newport with failing eyesight and increasing fatigue. But he had watched his son manage the family's legal affairs for 15 years, and he knew the texture of Richard's ambitions, and he had seen the way Richard looked at Crew, and the way Richard did not look at me, and he had understood that the document he had signed with Margaret would not survive the probate process without protection. So he had done three things. He had engaged Margaret as an independent notary outside the family's usual legal firm, leaving no trail through the attorneys Richard trusted. He had deposited a second certified copy of page 11 with a sealed instruction at the First Federal Trust in Providence, accessible only with a specific account number he had included in my educational trust documents. The same trust my parents had dismissed as modest and never examined, and he had written, in the final paragraph of his letter, "The document is sound, Olivia. I had it reviewed by two attorneys I found on my own. What they took from the filing is not a flaw in my intent. It is evidence of theirs. You will know what to do with that. You always did." I read that paragraph 3 times, then I folded the letter, placed it back in the envelope, and sat for a moment in the quiet of Margaret's office listening to the street noise below. "He was very fond of you," Margaret said. "I know," I said. I retrieved the Providence account number from Gerald's trust file that evening and drove to the First Federal Branch the following morning. The sealed deposit was exactly where Gerald had said it would be. A second certified copy of page 11, pristine, and with it, a signed affidavit from Gerald's two independent reviewing attorneys confirming the document's validity and their concern, noted at the time of review that the amendment was at risk of being excluded from the estate filing. They had written that concern down in a signed document. 11 years ago, I sat in my car in the parking lot of the First Federal Trust in Providence, with that affidavit in my hands, and understood for the first time the full architecture of what Gerald had built. He had not just written me a document, he had built me a case. I called Daniel from the parking lot. "I need you to clear your afternoon," I said. "How bad is it?" he asked. "It's not bad," I said. "It's the opposite." I looked at the affidavit. Daniel, he anticipated all of it. "There are two independent attorneys on record with a signed concern about suppression, dated before the probate filing. There's a second certified copy in a federal trust deposit. There's a notary who met with him privately outside the family firm and who spoke with him directly about the chain of custody." Silence on the line, Olivia. His voice was careful. "This isn't just a civil matter anymore." "No," I said. "It isn't." We met at his office at 2 o'clock. We spread everything across the conference table, the certified copies, Margaret's notarized seal, the first federal deposit record, the affidavit from the two reviewing attorneys, the public probate filing with the missing page 11. Daniel went through each document with a highlighter and a legal pad, building a timeline, noting every point where the evidence chain was unbroken. It took 3 hours. At 5 o'clock, he put his pen down, leaned back in his chair, and looked at the ceiling for a long moment. "The civil case is airtight," he said. "The trust activates as of your birthday. The shares and the Newport deed transfer to you by operation of law. There's nothing to file, it's automatic. What your family distributed at dinner has no legal effect. Crew gets nothing under the amendment, and the amendment supersedes the modified will on those specific assets." "And the rest?" I said. He looked at me. "The rest is a criminal matter. Removal of a page from a probate filing with intent to defraud a beneficiary. Your father was executor." He signed the filing, the office was quiet. Outside the window, the financial district was going dim, the last daylight pulling off the glass towers on Congress Street. "How long do we need?" I asked. Daniel thought for a moment. 6 weeks, maybe 8. "We need to secure every document under lock, brief a criminal attorney, identify the right venue for the civil action, and, most importantly, we need to do all of it before your family knows you have any of this." I nodded. I thought about my mother's voice on the phone the night before, warm and unhurried. "You've always been more independent." 6 weeks, I said. I drove home in the dark, made dinner, and went to bed at 10 o'clock. In the morning I put on my blazer, picked up my bag, and went to work. The call from Crew came on a Thursday, 17 days after my birthday dinner. I was at my desk at Hargrove & Associates reviewing a deposition transcript when my personal cell rang. The Harper number, the one only family used. I looked at his name on the screen for 3 full rings before I answered. I had been expecting contact. I had not expected it to come from Crew directly, because Crew had never once called me about anything that mattered. That was always Diane's role. The fact that he was making this call himself meant someone had decided a softer approach was needed first, and Crew was the closest thing the Harpers had to an emissary who did not immediately read as threatening. That calculation told me more than the call itself. "Liv," he said, using the nickname I had never asked for. "How are you doing?" "Haven't heard from you since the dinner," I've been busy, I said. Work, right, a pause. The kind that exists to create the impression of casualness. Listen, I wanted to check in. Mom mentioned you seemed a little off that night. We were both worried. I wrote the word worried on the corner of my legal pad and underlined it. I'm fine, I said. It was a long drive back. Sure, another pause. Outside my office window, a pigeon landed on the ledge and immediately left. Hey, so, Dad asked me to reach out about something. There's a document the firm put together, just a formality, really. Something about consolidating the trust structure going forward, simplifying the administrative side. Dad thought it would be easier for everyone if we got the signatures handled now, rather than letting it drag into the new year. I kept my voice completely level. What kind of document? Just you know, an acknowledgement. Confirming the estate distribution as outlined. Standard language, the attorneys drafted it. It would just confirm that everyone's on the same page about the arrangement going forward. I wrote the word acknowledgement on my legal pad. Below it I wrote, voluntary relinquishment of claim. Can you send it to me? I said. Yeah, absolutely. I'll have Dad's assistant email it over. It's really just a formality, Liv. 30 seconds, you read it. You sign it, done. He paused. I know things felt a little tense at the dinner. I want you to know that nobody thinks less of you for where you are right now. We're family. This is just about making sure the administrative side is clean. I thought about page 11 sitting in Daniel's locked filing cabinet. Send it over, I said. I'll take a look. The document arrived the following morning. It was 4 pages of precisely constructed legal language that did exactly what I had expected. Framed as an administrative clarification, it contained, in paragraph 7, a clause by which the signatory acknowledged the current estate distribution as final, complete, and reflective of the decedent's intent, and waived any future claim to additional assets or interests not explicitly enumerated in the current filed will. It was not a formality. It was a termination of my rights dressed in the language of housekeeping. I forwarded it to Daniel with a single line. See paragraph 7, he replied 11 minutes later. Don't sign. Don't respond yet. Come in tomorrow. I did not sign. I did not respond to crew. I let 4 days pass, which I knew would create pressure, and I spent those 4 days at work, at the gym, at the grocery store, living the visible life of a woman who had no idea what was in a sealed filing cabinet 2 blocks away. On the 5th day, Richard called. My father rarely called me directly. In my memory, I could count on one hand the number of times he had initiated a phone call to me specifically. Not the family calls where Diane handed the phone over for 2 minutes, but a call placed by Richard Harper to his daughter. The fact that he was calling now meant the soft approach had not produced results, and the timeline was tightening in ways I could not yet see. He opened with pleasantries. He asked about my apartment, whether I needed anything, whether Boston winters were treating me well. Richard Harper was a man who believed sincerely that a few minutes of warmth at the beginning of a conversation entitled him to whatever he needed at the end of it. I had watched him use this technique in every difficult conversation I had ever witnessed him have. And I had learned to track the moment when the warmth ran out and the actual purpose arrived. It took him 6 minutes. Olivia, I want to speak to you frankly. Which in my father's vocabulary meant he was about to say something he had already decided was non-negotiable and wanted me to receive it as candor. The document crew sent over is genuinely administrative, but I want you to understand that there is a reason we need it signed promptly. We have some investors looking at the company right now, serious people, and a clean ownership structure it's essential for the process. Any ambiguity in the trust documentation creates complications we can't afford at this stage. I noticed the word ambiguity. He had used a legal term. Someone had briefed him on how to phrase this. I understand, I said. Good, he sounded relieved. I'm glad. So you'll get that back to us? I'd like to have my own attorney review it first, I said, just to make sure I understand what I'm signing. I'm sure you can appreciate that. A silence. Brief, but not brief enough, of course, he said. Yes, of course. Take a few days. Thank you, Dad. After we hung up, I sat for a moment in my desk chair and thought about the investors he had mentioned. Real or fabricated, the claim told me something useful. The timeline my family was working on was shorter than 6 weeks. Something was moving at the company level that made a clean ownership structure urgent, which meant they needed my signature before something became public. I texted Daniel. Need to move faster. Dad mentioned investors. Something's in motion at the company. He replied within the minute. Already on it. I pulled the Harper & Wren public filings this morning. There's a merger discussion in the preliminary disclosure documents. Filed 8 days ago. I stared at that for a long moment. A merger. 51% of Harper and Wren Holdings, Gerald's voting shares, my shares by operation of law as of October 14th, would be the controlling interest in any merger negotiation. Whoever held those shares held the decision. My father had filed merger preliminaries 9 days after my birthday, 9 days after the trust clause activated, and the shares transferred to me by law, without my knowledge, without my signature, and without my family's acknowledgement that any transfer had occurred at all. They were not trying to consolidate an estate. They were trying to close a merger using shares that legally belonged to me, before I found out they legally belonged to me. I put my phone face down on the desk and looked at the wall for a long moment. Then I picked it up again and called Daniel. The merger, I said, when he answered. I know, he said. How long before it closes? Preliminary filing suggests 60 to 90 days to final agreement, but the controlling interest vote would need to happen well before that. Maybe 30 days, 30 days. We had planned for 6 weeks. We now had 4. Can we move the timeline? I said. I've already started, he said. I reached out to Patricia Hollis this morning. Patricia Hollis was a criminal defense and white-collar crime attorney at Mercer and Hollis, one of the 3 firms in Boston I would have called for exactly this situation. She was 60 years old, sharp-edged, and had a reputation for being unmoved by wealth or family names, which in this city was rarer than it should have been. What did she say? I asked. She said, and I'm quoting directly, Daniel said, that she had been waiting for someone to bring her a case like this for 20 years. I almost smiled. Set the meeting, I said. The rumors reached me on a Monday morning in November, the way rumors always reach their subjects, sideways. Through someone who assumed I already knew, a law school acquaintance named Priya sent me a text at 8:47 while I was walking to the office. Hey, heard something about you at the Aldrich dinner Saturday. Hope you're okay. Call me if you need to talk. I stopped on the sidewalk on Congress Street, a cup of coffee in one hand, and read it twice. I called her from a bench near the park. Priya had been at the Aldrich's Saturday dinner, the same Aldrich's from the Newport Country Club, the same family who had been seated 3 tables away from me on my birthday. She told me carefully that Diane Harper had been at the dinner, and that during conversation Diane had mentioned, with apparent reluctance and the specific tone of a woman who wants to be overheard, that Olivia had been struggling for some time. That the family had tried to be supportive. That there were concerns. Nothing specific. Diane had not said anything specific. But the implication was textured enough that several people at the table had asked follow-up questions. And by the end of the evening, the general understanding was that Olivia Harper was unstable, possibly bitter, and that the estate arrangement had been structured the way it had been for reasons the family preferred not to discuss publicly. I thanked Priya, told her I was fine, and hung up. I sat on the bench for 3 minutes watching traffic move on Congress Street. Then I stood up, threw my coffee cup in the trash, and walked to the office. Dan Harper had spent 40 years building a social architecture in which her version of events was the one that circulated first. She understood, with the precision of someone who had studied the mechanics of reputation, that the story told before the other person can respond is the story that sticks. She was not lying exactly. She never lied exactly. She was creating a context, a frame. If Olivia Harper later appeared with documents and attorneys and legal claims, that appearance would be filtered through what the Aldriches and their dinner guests already believed. That Olivia was the unstable one, the difficult one, the one the family had quietly tried to manage for years. It was elegant in the way that cruelty sometimes is when practiced by someone with long experience. I told Daniel that afternoon. He nodded in the way he nodded when something confirmed what he had already suspected. Crew filed something this morning, he said. He slid a document across the conference table. It was a motion filed with the probate court requesting a formal confirmation of the estate distribution as finalized, essentially asking a judge to rubber stamp what had already been submitted, closing the door on any challenge before one could be mounted. The motion had been filed under the family's usual firm, and it had the particular quality of something drafted in haste. The language was precise, but the margins were slightly off, the way documents are when someone has stayed late to finish them. The filing had been time-stamped at 7:14 in the morning. Someone had been at that firm before 7 a.m. on a Monday. They know something is moving, I said, or they're being cautious because you didn't sign the acknowledgement, Daniel said. Either way, the motion accelerates our timeline. If the court confirms the dispute before we file our challenge, it complicates the civil case. Not fatally, but it adds a layer. How long do we have? The motion has a 14-day response window. Standard probate procedure. He looked at me. We need to file our challenge within that window, 14 days. Patricia Hollis had been building the criminal referral package for 2 weeks. The civil filing was drafted but not finalized. We needed 3 things to happen in a specific order: secure the original Margaret Wren notarized copy under court protection, file the civil challenge before the confirmation motion was granted, and deliver the criminal referral to the DA's office in a way that did not give Richard time to construct a response before the filing was public record. That evening, Daniel and I sat in the Hargrove conference room until 9 o'clock, mapping the sequence on a whiteboard. The room smelled like stale coffee and dry erase marker. The cleaning crew vacuumed around us without comment. When we finished, Daniel took a photo of the whiteboard, and I erased it. The following week, crew called again. This time he skipped the pleasantries entirely, which told me the internal temperature had risen. Olivia. His voice had the clipped quality it got when he was annoyed and trying not to sound it. We need the document signed. The investors are doing their diligence, and the attorneys need a clean record. This is not a complicated ask. I'm still having it reviewed. I said, by who? You don't even have a lawyer. I did not correct him. I want to make sure I understand what I'm signing, I said. That seems reasonable. It's been 3 weeks. His voice shifted, sharpened. Look, I'm going to be straight with you, because I think that's better than dancing around it. If you make this difficult, if you decide to be difficult about this, for whatever reason, the family is going to have to revisit what support looks like going forward. The 5% interest, the account access, all of it. Dad is not going to continue funding a situation where someone is actively working against the family's interests. I wrote the word threat on my notepad, very small, and drew a box around it. I appreciate you being straight with me, I said, so you'll sign it. I'll be in touch soon, I said, and ended the call. That same afternoon, Diane escalated. She did not call me. She called 3 people who knew me: a college friend named Sophie, my former roommate Jade, and, most deliberately, my academic advisor from BU, a woman named Dr. Renata Collins, who had written my law school recommendation letter. To each of them, Diane said some version of the same thing: that she was worried about Olivia, that Olivia seemed to be developing an unhealthy fixation on the estate, that the family was doing everything they could, but that Olivia had always had difficulty with reality when things did not go the way she wanted. Dr. Collins emailed me directly. She wrote, "Your mother called me today. I want you to know I said nothing that wasn't in your recommendation letter, and I think you should know this call was made." I forwarded that email to Daniel and Patricia within the hour. Patricia replied in 4 minutes. Perfect. Obstruction of a potential witness. I'll add it to the package. I kept going to work. I kept returning emails in the tone of someone who had nothing to prepare. I went to the grocery store and the gym and a friend's birthday drinks on a Friday night, and I smiled and laughed and talked about things that had nothing to do with any of this, because the single greatest advantage I had in this entire situation was that my family had spent 21 years practicing the art of not taking me seriously. They were still practicing it. Meanwhile, Daniel filed for court protection of the Margaret Wren document on a Wednesday afternoon. The filing went through under the docket of Hargrove and Associates, listed under a matter number rather than a party name. Standard procedure for a protective filing, nothing visible to a casual search. Margaret received the court notification the following morning. She called my cell at 9:15. "I've been waiting for this," she said. "I know," I said. "Thank you for holding it." "Gerald told me to hold it as long as necessary," she said. "He said you would come when you were ready and not before." After we hung up, I stood at my office window for a moment, looking at the street below. We were 4 days from the 14-day response window. Patricia submitted the criminal referral package to the Suffolk County DA's office on a Thursday. The package was 43 pages. It contained the complete document chain: Margaret's signed affidavit, the 2 independent attorneys' signed statement of concern from 11 years ago, the first federal trust deposit record, a timeline of the probate filing cross-referenced against Richard's role as executor, and the recording of Richard's conversation with me, the one in which he had said he had handled the Toze Tua, which Patricia had flagged as a direct admission of knowledge. She had also included Diane's calls to Dr. Collins and the others, documented and timestamped as evidence of an active campaign to discredit a potential claimant. The DA's office assigned an investigator the following morning. On Friday, Daniel filed our formal challenge to the estate distribution in Suffolk County Probate Court. He filed it at 4:58 in the afternoon, 2 minutes before the clerk's office closed, under the full legal name, Olivia Ann Harper v. The estate of Gerald Richard Harper, Richard T. Harper as executor, and Harper & Wren Holdings LLC, at 5:03. As I was gathering my bag to leave the office, my phone rang. It was Crew. I did not answer. I walked out onto Congress Street in the early dark of a Boston November evening, the cold coming off the harbor 2 blocks away, and I thought about Gerald on the porch in Newport, the Sunday morning light, the way he had looked up from his newspaper once and said, without preamble, "The quiet ones always win in the end, Olivia. They just have to be willing to wait." I had waited. The wait was almost over. The meeting was my idea, and I chose the location carefully. Not the Harper estate. Not a restaurant where my father would feel the social armor of familiar surroundings. Not a law office, which would have put him immediately on alert. I chose a hotel bar in downtown Providence. The kind of place that was quiet on weekday afternoons, dark-paneled, unhurried, neutral ground that belonged to neither of us. I told my father I wanted to talk privately, that I had been thinking about the document, that I was close to a decision, and wanted to speak with him directly before I involved anyone else. I used the phrase "before I involved anyone else" deliberately. Richard Harper had spent 30 years reading rooms and reading people, and the phrase was calibrated to land in a specific place. It suggested I was still alone, still uncertain, still considering cooperation. It suggested that the decision had not yet been made, that there was still a version of this where he walked away intact. He agreed to Providence immediately, which told me the merger timeline was pressing harder than I had known. I told Daniel the night before. He was quiet for a moment. "You're going to let him talk," he said. It was not a question. "I'm going to let him talk," I said. "Rhode Island is a one-party consent state," he said. "I know," I said. "I'll be in the parking garage across the street." I arrived at the hotel bar 20 minutes early and chose a corner table, back to the wall, clear sightlines to the entrance. I ordered sparkling water and sat with my hands relaxed on the table and watched the afternoon light move across the polished wood floor near the windows. A bartender wiped glasses at the far end of the bar. 2 men in suits talked quietly over a business lunch they were finishing. The room had the particular hush of a place that understood discretion was part of function. My father arrived at 2:02. Richard Harper at 64 looked like a man who had always been comfortable. Not ostentatious, that was Crew's register, but settled, assured, the kind of comfortable that comes from never having spent a significant period of time uncertain about where next month's money was coming from. He was tall, gray at the temples, wearing a dark coat he had not yet removed. He scanned the room when he entered, found me, and crossed to the table with the smooth, unhurried movement of a man who believed he was in control of what was about to happen. He sat down. He ordered bourbon. He looked at me with the particular expression he had used my entire life when he wanted something from me and was prepared to be patient about getting it. Warm, measured, slightly paternal, as if I were still 12 and he were explaining something complicated for my own good. "I'm glad you called," he said. "I think this is the right way to handle it." "Between family, I thought so too," I said. We talked for a few minutes about nothing. The drive down, the weather, whether Providence had changed since he last spent time here. Richard was good at the preliminary warmth. He had practiced it long enough that it came naturally, and I let it run its course without rushing him, because rushing him would have changed the register of the conversation, and I needed him relaxed. When the bourbon arrived, he took a sip and set it down and shifted slightly in his chair, and I recognized that shift. It was the movement he made when he was done with the preamble and ready for the substance. So he said, the document, I said. "I've been thinking about it a lot." "Good," he nodded. "Olivia, I want you to understand something. The arrangement your mother and I put in place is genuinely what's best for the family long term. Crew has a vision for the company. He has relationships with the right people. He understands the industry. He's been preparing for this for years. The 5% interest we've structured for you is not nothing. It generates income. It keeps you connected to the family legacy. It's a foundation." "A foundation," I repeated. "Exactly." He looked at me steadily. And frankly, Olivia, the document you've been asked to sign simply confirms what's already in place. It's not taking anything from you. It's acknowledging the reality of where things stand. I looked at my sparkling water. Dad, I said, keeping my voice quiet and slightly uncertain, the register he expected from me, the one I had played my whole life. Can I ask you something honestly? Of course, was there ever? I found some of Grandpa Gerald's old papers. When I was going through things after his funeral, there was a mention of some kind of amendment to the will. I could never find anything about it, and I assumed it was nothing, but I paused, looked up at him. Was there something like that? That got sorted out during probate? The change in his face was small. It would have been invisible to someone who hadn't spent a lifetime studying him. A slight tension at the jaw, a fractional stillness behind the eyes before the warmth reasserted itself. Gerald made a lot of notes toward the end, he said. He had some ideas that weren't. He wasn't always thinking clearly in his last year, Olivia. You know that. We had the estate reviewed very carefully by the firm. Everything that was legally sound and reflective of his actual intentions was included. So there was something, I said. There were drafts, he said. Preliminary thoughts. Nothing that held up legally. I nodded slowly, as if processing this. What happened to them? The second shift was more careful than the first. He lifted his bourbon glass, took a measured sip, set it down. The firm handled all of that during probate, he said. Standard procedure. Documents that don't meet the legal threshold for inclusion are noted and filed. It's administrative. Filed where? A pause. Brief. The length of a breath drawn slightly too carefully, Olivia. His voice carried the first edge of impatience now, wrapped in something that still wanted to sound like patience. I need to know if you're going to sign the document. That's why we're here. I looked at him for a moment. I thought about Margaret Wren's office on Tremont Street, and the sealed envelope, and Gerald's handwriting on the front. I thought about the First Federal Trust in Providence, 15 minutes from where we were sitting. I thought about a signed affidavit from two attorneys who had written down their concerns 11 years ago and had the discipline to keep them on record. Dad, I said, I want to understand what happened to the amendment. The one on page 11, the glass stopped moving. It was the number that did it, not the word amendment, not the word will, but the specific number. Page 11, the precision of it. The fact that I had named the exact page told him, in the space of a second, that I was not working from vague suspicion or old emotional grievance. I had the document, or I knew someone who did. He set the glass down on the table very carefully. I don't know what you think you've found, he said. His voice had changed completely. The warmth was gone. What was underneath it was not angry, exactly. It was the voice of a man recalibrating, quickly, with the discipline of someone who had managed difficult situations for decades. But I would strongly encourage you to be very careful, Olivia. Very careful. You are 21 years old. You don't understand how these things work. I'm a licensed attorney, I said. I've been practicing for 14 months under the name Olivia Wren at Hargrove and Associates in Boston. I think I have a reasonable understanding of how these things work. The silence that followed was the longest of the afternoon. Richard Harper looked at me across the table with an expression I had never seen on his face before in my life. It was not anger. It was not contempt. It was something closer to recognition, the particular look of a man who has underestimated something for a very long time and has just, in one clear moment, understood exactly how much that underestimation has cost him. He said nothing. The amendment is sound, I said. Gerald had it reviewed independently. There are two attorneys on record, with a signed statement of concern about its exclusion from the probate filing, dated before the filing was submitted. There is a certified copy with a notary seal outside the family's legal chain. There is a second certified copy in a federal trusted deposit in this city. I paused. And there is a recording of this conversation. His jaw tightened. I did not come here to negotiate, I said. I came here because I wanted you to understand, before the formal proceedings begin, that I have everything. I wanted you to know that Gerald made sure of it. Richard sat very still for a long moment. The bourbon glass was untouched. Then he reached for his coat, stood up and walked out of the hotel bar without another word. I sat alone at the corner table for a few minutes after he left. The bartender was still polishing glasses at the far end. The two men in suits had finished their lunch and gone. I took out my phone and texted Daniel. He confirmed knowledge of the page. On record, come get me. His reply came in 40 seconds. Walking in now. Outside in the parking garage, Daniel had the recording running from the moment my father sat down. Clean audio, full conversation, Richard's voice stating clearly that documents which did not meet the legal threshold had been handled during probate, that there had been an amendment that hadn't held up legally, delivered in the voice of a man who had never once imagined his daughter was listening with the trained ear of an attorney. Patricia Hollis received the audio file at 4:15 that afternoon. She called me at 4:40. That, she said, is the last piece. The meeting was scheduled for a Thursday morning in December, 3 weeks after Providence. It was held at the offices of Mercer and Hollis on the 31st floor of a building on Federal Street. Chosen because it was Patricia's territory and because the conference room had floor-to-ceiling windows that looked out over the harbor, which meant that everyone seated at the table would have, at the edge of their peripheral vision, the particular clarity of open water on a cold day. Something that reminded people, without words, that the world was larger than the room they were sitting in. The invitations had gone out under Patricia's letterhead 12 days earlier, formally requesting the presence of the named parties for a reading and review of newly submitted probate materials in the matter of the estate of Gerald Richard Harper. The language was precise and procedural, and gave away nothing beyond the necessity of attendance. Patricia had also sent simultaneously a courtesy notice to the Suffolk County DA's investigator assigned to the criminal referral, informing him of the date and time. By 8:50 in the morning, 7 members of the Harper and Wren Holdings Board of Directors were seated along one side of the conference table. They had received their own letter, separate from the families, notifying them that a matter affecting the controlling interest structure of the company required their presence at a formal review. 3 of them I had never met. 2 of them I recognized from the Newport Country Club, men in their 60s who had known Gerald, and who had the particular stillness of people who understand that they are about to learn something they will wish they had known sooner. Margaret Wren sat to my left, her notary seal in a small leather case on the table in front of her. Daniel sat to my right, a legal pad already open, pen uncapped. Patricia sat at the head of the table, her reading glasses on, a stack of documents aligned with the edge of the table in front of her, with the precision of someone who considers visual order a form of argument. My family arrived at 9:05. Crew came first, with 2 attorneys from the family firm, both of whom I recognized from the birthday dinner, the men with the leather portfolios. They took their seats on the opposite side of the table, with the composed efficiency of people who had been told this was a procedural formality, a final administrative step before the merger confirmation vote. Crew was in a dark suit, hair combed, the expression of mild impatience he wore when he considered his time being used inefficiently. He glanced at me once across the table and then looked at Patricia, already performing the social calculus of a man who wanted to establish that the woman at the head of the table was someone he should address directly, rather than the woman sitting 2 seats away. Richard came in behind him. He did not look at me. Diane arrived last. She wore a gray wool coat and pearl earrings, and she carried herself with the upright composure of a woman who had never once walked into a room and felt she did not belong at the center of it. She sat down next to Richard, folded her hands on the table, and looked at Patricia with the expression she used for service professionals. She considered a punt, but not quite her social equal. She had not yet looked at me. I had not yet looked at her. Patricia let the room settle for exactly 30 seconds. It was a specific technique. The silence long enough to signal authority, short enough not to seem theatrical. Then she opened the top folder in her stack and said, in the level tone of someone reading from a prepared text, "Thank you all for being here this morning. We are convened to review materials newly submitted to the Suffolk County Probate Court in the matter of the estate of Gerald Richard Harper, specifically concerning a testamentary amendment executed by the decedent on April 9th, 11 years ago, which was excluded from the probate filing submitted by the estate executor following Mr. Harper's death. One of the board members, a man named Warren Aldrich, the elder of the 2 I recognized, shifted in his chair. Crew's lead attorney said, our understanding was that this was a confirmatory review of the existing distribution. Your understanding was incomplete, Patricia said, without looking up from the folder. Please hold questions until the document presentation is complete. She nodded to Margaret. Margaret Wren opened her leather case, removed the certified copy of page 11 with both hands, and placed it on the table. It was a single page. Heavy cream stock, slightly aged at the edges, with the clear black type of a document produced on a proper legal typewriter. At the bottom were 3 signatures: Gerald's, large and deliberate; Margaret's, precise and formal; and 2 witnessing signatories, their names printed below in block letters. In the lower right corner, Margaret's notary seal, embossed and unmistakable, Patricia, plus beside it the certified copy from the First Federal Trust deposit. Identical. Then the affidavit from Gerald's 2 independent reviewing attorneys. Then the First Federal Deposit record showing the date and account number. Then the timeline document, 16 pages, cross-referenced, showing the page numbers of the original filed will against the page numbers of the complete document, with the gap at page 11 marked in red. Then she placed the audio transcript on the table. The room was very quiet. Crew leaned forward, looked at the page 11 document, and turned to his attorneys with an expression that had lost all of its composure. One of the attorneys was already scanning the affidavit. The other had gone still in the way people go still when they are recalculating a situation that has turned out to be significantly different from what they were briefed on. Richard was looking at the table. I watched him look at the table. Patricia said, "Under the terms of the testamentary amendment, a conditional trust in the name of Olivia Ann Harper was established, funded by 51% of the decedent's voting shares in Harper and Wren Holdings, and the deed to the Newport estate located at." She read the address, with an activation date of October 14th of this year, contingent on the beneficiary reaching the age of 21. As of that date, the trust activated by operation of law. The shares and the deed transferred automatically to the trust. No filing, signature, or acknowledgement by any other party was required or permitted, one of the board members said quietly. The merger vote, yes, Patricia said. The controlling interest in Harper and Wren Holdings has been held in trust for Olivia Ann Harper since October 14th. Any board action taken or proposed on the basis of a different ownership structure during that period was taken without the knowledge or authorization of the controlling interest holder, Crew said. This is, and then stopped. Because his attorney put a hand briefly on his arm, Patricia looked at me. I had been waiting for this moment. Not with triumph. I want to be precise about that. There was no part of me that wanted to perform anything in this room. What I felt was something quieter and more specific. The particular steadiness of someone who has carried something heavy for a long time and has finally set it down in the right place. I stood up. The room looked at me. The board members. The attorneys. Diane, for the first time since she had walked in, turned her head and looked directly at me across the table. I looked back at her for a moment. Her face was composed, but her hands, folded on the table, had tightened. My name is Olivia Ann Harper, I said. I am also known professionally as Olivia Wren Esquire, Associate Attorney at Hargrove and Associates in Boston. I am the named beneficiary of the testamentary amendment you have just been presented. I am the controlling interest holder of Harper and Wren Holdings as of October 14th, and I am represented in this matter by Patricia Hollis of Mercer and Hollis and by Daniel Chu of Hargrove and Associates. I paused. I did not come here to relitigate the past. I came here to establish the present. The company my grandfather built belongs, by his expressed and legally documented intent, to the person he chose to leave it to. That choice was made carefully, witnessed properly, and stored outside the reach of anyone who might want to change it. I looked at the board members directly. I would like to schedule an introductory meeting with the board at your earliest convenience. I have some thoughts about the direction of the company. Warren Aldrich looked at me for a long moment. Then he said, quietly but clearly, "We would welcome that, Miss Harper." The door at the far end of the conference room opened. 2 men in plain clothes entered. One of them carried a badge. He looked at Patricia, who nodded once, and then he looked at Richard Harper. "Mr. Harper," he said, "I'm Detective Ramos with the Suffolk County DA's office. I'd like you to come with me." Richard stood slowly. His face had the quality of something that has been holding a shape for a long time and has finally stopped. Crew said, "Dad." Richard did not look at him. He did not look at me. He picked up his coat from the back of the chair with the automatic movement of a man performing a familiar action in an entirely unfamiliar situation, and he walked toward the door with Detective Ramos. And the room watched him go in complete silence. Diane Harper did not move from her chair. I looked at her across the table. She was looking at the page 11 document in front of her. The single cream-colored page with Gerald's signature at the bottom, large and deliberate. The handwriting of a man who had known exactly what he was doing. Her composure had not broken. I had not expected it to. Diane Harper was not the kind of woman whose composure broke in public, but her hands, still folded on the table in front of her, were no longer perfectly still. I sat back down, opened my notepad, and wrote the date at the top of the first page. Outside the floor-to-ceiling windows, Boston Harbor was gray and cold and completely clear, the kind of day Gerald would have called a good porch morning. I thought that too. The room took approximately 90 seconds to understand what had just happened. I know because I counted, the way I had learned to count things. Not from anxiety, but from the habit of a person who had discovered early that precise observation was the only reliable defense against a world that preferred she remain unobserved. 90 seconds from the moment Detective Ramos and his partner led Richard Harper toward the door to the moment the first attorney on the opposing side pushed back his chair and began quietly gathering documents into his briefcase. That movement, the quiet gathering of documents, was the signal the room had been waiting for. Crew's lead attorney, a man named Garrett Foss, who had been with the Harper family firm for 15 years, leaned toward Crew and said something in a voice too low for me to hear. Whatever he said produced a visible change in Crew's face, the last remnants of his composure reorganizing themselves into something harder and less controlled. Crew looked at me. "This is not over," he said, his voice carried across the table without difficulty. It had the quality of a statement made for the benefit of the room, rather than for me specifically. The reflex of a man who had spent his life performing authority and could not immediately locate a different register. "You don't understand what you're walking into. You have no idea how this company actually operates. You've been hiding in a law office for 3 years playing a game you invented in your own head, and when the reality of running a real organization hits you..." "Mr. Harper," Patricia's voice was level and final. "I would strongly advise you to stop speaking." Crew stopped. Foss put a hand on his arm, one of the board members, a man named Philip Greer, who had been Gerald's first outside investor in 1974, and who had the particular authority of someone whose history with the company predated everyone else in the room, looked at Crew with an expression that was not unkind, but was entirely without deference. "Crew," he said, "sit down." The simplicity of it landed differently than any legal language had. Crew sat. The two opposing attorneys asked for a brief recess. Patricia granted 10 minutes. Most of the board members stood and moved toward the windows, speaking quietly among themselves in the way of people processing a significant recalibration. I stayed in my seat. Daniel refilled my water glass from the carafe on the table. Margaret Wren was methodically returning her documents to their case, with the unhurried precision of someone whose work here was complete. I looked at Diane. She had not moved from her chair since Richard left the room. Her coat was still on. Her hands were in her lap now, no longer on the table. She was looking at a fixed point on the far wall, with the focused stillness of a woman marshalling every resource available to her, which was considerable. Diane Harper had survived 40 years of difficult rooms. She was not going to come apart in this one. But something had changed in her face. It was subtle, the kind of change only visible to someone who had spent a lifetime reading her. A faint loosening around the jaw. A quality in the eyes that was not grief exactly, but was adjacent to it. The particular expression of a person who has built something very carefully over a very long time, and has just watched the architecture reveal its central flaw. She had not accounted for Gerald. That was the core of it. For all her precision, all her social engineering, all the careful management of narratives and relationships and rooms, she had not accounted for the fact that Gerald had known her as well as she knew everyone else. He had watched her for 40 years too. He had simply been quieter about what he saw. After 10 minutes, the attorneys returned. Foss asked several procedural questions about the civil filing timeline, which Patricia answered without elaboration. The second attorney asked about the merger preliminary disclosure and whether it would need to be withdrawn. Patricia said that any action taken on the basis of the prior ownership structure would need to be reviewed in consultation with the new controlling interest holder, and that she would be in contact with the relevant parties through proper channels. Then Philip Greer asked to speak. He had remained standing at the window during the recess, and now he returned to his seat and looked at me directly, the way he had not quite done before, the full attention of a man deciding something. "I knew Gerald for 51 years, he said. "We built the first building in Providence, with borrowed money and a handshake agreement. He told me once, maybe 15 years ago, that he was not worried about the company. He said he had made sure the right person would have it. Greer paused. I didn't understand what he meant at the time. He looked at me steadily. I think I understand now, he said. I held his gaze. Thank you, Mr. Greer. He nodded once, the brief nod of a man who considers the matter settled, and turned to speak quietly with the board member beside him. At 11:40, Foss requested that the board vote on the immediate suspension of Crew Harper's acting executive authority pending legal review of all actions taken during the period in which the ownership structure had been misrepresented to the board. The motion was procedural. Foss was protecting his client from additional liability, distancing the firm from decisions made under false pretenses. It was the move of a careful attorney rather than an ally, but it served the same purpose. The board voted. 6 in favor. 1 abstention, a man named Caldwell who had been brought onto the board by Richard 3 years ago, and who now had the expression of someone calculating the distance between his current position and the nearest exit. Crew said nothing during the vote. He sat at the table, with his hands flat on the surface, and his jaw set, and his eyes directed at no one. And I watched him perform the particular stillness of a person who has spent their entire life being told they were the important one, and has just, in a single morning, had that certainty removed. I did not feel satisfaction watching it. I want to be accurate about that too. What I felt was something closer to tiredness. Not the exhaustion of someone who had lost, but the specific tiredness that comes after a long, careful effort has finally reached its conclusion. The kind of tiredness you can rest in. The formal portion of the meeting ended at 12:10. The board members collected their things and began filing out, several pausing to speak briefly with Patricia or with me. Warren Aldrich shook my hand and said he was glad the record had been corrected. Philip Greer paused at the door and looked back at me once more, with an expression I could not fully read, something between assessment and approval, and then walked out. Foss and the second attorney left with Crew between them, speaking to him in low, urgent voices as they moved toward the elevator. Crew did not look back. I was gathering my own documents when Diane stood up. She put on her coat with the automatic grace of a woman who had dressed herself beautifully for 50 years, and did it without thinking. She picked up her bag. She turned toward the door. Then she stopped. She stood with her back to the room for a moment. Just a moment, 2 or 3 seconds, the length of a breath held and released. Then she turned and looked at me. Her face was composed. Her pearls were straight. Her posture was what it had always been. But her eyes, for the first time in my memory, did not carry the particular authority she had always wielded. The authority of a woman who knew exactly how the story ended because she had written it herself. She said nothing. I said nothing. There was nothing left to say that the morning had not already said more clearly than either of us could manage with words. She walked out. The conference room was empty except for Daniel and me and Margaret Wren, who was latching the small leather case that held her notary seal. The floor-to-ceiling windows showed the harbor, gray and cold and still. Daniel set down his pen and looked at me. "How are you?" he asked. It was a simple question and he meant it simply, and I appreciated that more than I could easily explain. The fact that after 3 months of strategy and sequence and careful, calculated movement, the first thing he asked when it was over was not what comes next, but how I was. "Tired," I said. "Good tired." He nodded. Outside in the corridor, my phone buzzed. A text from a number I did not recognize. I opened it. It was from Detective Ramos. "Mr. Harper is in custody. Processing will take several hours. You may be contacted for a statement. Thank you for your cooperation, Miss Harper." I read it twice, then put the phone in my bag. Margaret closed her leather case and stood. She looked at me with the expression she had worn in her office on Tremont Street, measured, warm, the expression of someone who has held something precious in trust for a long time and is satisfied with how it has been received. "He would have been very proud," she said. I looked at the harbor for a moment. "I know," I said. Richard Harper entered a guilty plea 4 months after the December meeting. The charge was fraudulent concealment of a testamentary document with intent to deprive a named beneficiary, a felony under Massachusetts law, carrying a potential sentence of up to 5 years. Patricia negotiated a disposition that resulted in a suspended sentence, 3 years of supervised probation, a substantial civil fine, and a permanent bar from serving as executor or trustee of any estate in the Commonwealth. His attorneys argued for leniency on the basis of his age and his lack of prior criminal record. The judge granted the suspended sentence. She did not grant the request to seal the record. The plea was entered on a Tuesday morning in March. I was not required to be present. I went to work. I heard about it from Patricia at noon. I ate lunch at my desk, and then went back to the contract I had been reviewing, because that was what the day required, and because I had learned over the previous 6 months that the most reliable way to process large things was to keep doing small things steadily until the large thing settled into its proper place in the architecture of your life. Crew's removal from Harper and Wren Holdings was completed in January, 6 weeks after the December meeting. The board voted unanimously. Caldwell had resigned in late December, which made the vote clean. Crew retained his personal inheritance under the original will, which had not been contested. He retained the money. He did not retain the company, the Newport estate, or the position he had spent his entire life being groomed for. Last I heard, he was consulting for a smaller real estate firm in Connecticut, work that paid well enough and required no one to look too closely at the previous 3 years of his employment history. I did not reach out to him. He did not reach out to me. Diane was a more complicated question, and I will not pretend otherwise. She had not been charged with any crime. There was no evidence she had known about the missing page before Richard removed it from the filing. Or rather, there was no evidence admissible enough to prosecute. Whether she had known or simply chosen not to ask was a distinction the law could not adjudicate, and that I had stopped trying to adjudicate myself. What I knew was that she had spent 21 years building a household in which I was the lesser child, and that this had been a choice she made and remade every morning, and that the law's inability to address it did not change what it was. She called me once, in February. I let it go to voicemail. She left a message that was 3 minutes long and carefully composed, the way all her communications were carefully composed. And in it she said that she hoped I understood, the family had always loved me, that decisions had been made under difficult circumstances, that she hoped in time we could find a way forward. She did not say she was sorry. I had not expected her to. I did not call back. That was not cruelty, it was accuracy. There was no version of a conversation between us that would produce anything either of us needed. Some relationships end not with a confrontation, but with a silence that becomes, over time, its own complete statement. I moved into the Newport estate in April. The house had been held in the trust since October, legally mine for 6 months before I set foot in it as its owner. I had delayed the move deliberately. There was work to finish in Boston, a transition to manage at the firm, 100 practical reasons to wait. But the real reason, the one I admitted to myself on the drive down, on a Saturday morning in early spring, with the windows open and the smell of the ocean arriving before the coastline did, was that I had needed time to be ready to walk through those doors as myself. The wraparound porch caught the Atlantic wind the way it always had. I stood on it for a long time the first morning, coffee in hand, watching the light move across the water. The garden needed work. One of the shutters on the east side had come loose over the winter. The kitchen required updating. There was a list, and the list was satisfying in the specific way that practical work is satisfying after a long period of strategic thinking. The pleasure of problems that can be solved with a phone call and a reasonable budget rather than with a carefully sequenced legal filing. I had Gerald's copy of Black's Law Dictionary on the mantelpiece in the study. I had put it there the first day. The board meeting in January had gone 3 hours and covered the foundational questions any board asks when a controlling interest changes hands: direction, priorities, personnel, the merger discussion that had been suspended pending resolution of the ownership matter. The merger, as it turned out, had been premature, and the board had known it, had been uncomfortable with the timeline Richard was pushing, and were relieved to have a reason to step back and reassess. We tabled it indefinitely, and turned instead to a capital improvement plan for 2 of the older properties in the portfolio that had been deferred for years, because Crew's focus had been on acquisition rather than stewardship. Gerald's word, stewardship. Diane had used it at the birthday dinner in October, and I had noticed the irony then, and noticed it again now. The way certain words mean entirely different things depending on who speaks them and what they are actually prepared to do. Philip Greer retired from the board in February, his decision made gracefully. At his farewell dinner, a small gathering at a private room in Providence, 8 people, no speeches, he pulled me aside before we sat down and said that Gerald had told him once, in the last year of his life, that the company would be fine, that he had taken care of it. I told Greer what Gerald had written in the letter, not the private parts, Those I kept. But the last paragraph, the document is sound. What they took from the filing is not a flaw in my intent, it is evidence of theirs. You will know what to do with that. You always did. Greer was quiet for a moment. Then he said, that sounds exactly like him. It did. Daniel made partner at Hargrove in the spring, which was overdue, and which he received with the particular understated satisfaction of someone who had been doing partner-level work for 2 years already. I attended the small celebration the firm held for him, and gave a toast that made him visibly uncomfortable, which was exactly what the moment called for. I formally changed my professional name back to Olivia Harper in March, filed the paperwork, updated the bar registration, had the nameplate on my office door replaced. The name Wren had served its purpose. It had been a shelter while I needed shelter and a tool while I needed a tool, and I was grateful for it, but it was not my name. My name was Harper. Gerald's name. The name on the building. I kept it. 6 months after the December meeting, I stood on the porch on a Sunday morning with a cup of coffee and a clear day in front of me, the Atlantic doing what it did, unhurried and indifferent, and enormous. The porch furniture was new. I had replaced the old set in May with something simpler, closer to what had been there when Gerald was alive, and we sat together reading without speaking. I had his newspaper habit now. I read the financial section first. I thought about him that morning. The cedar and coffee smell, the wide hands, the way he looked up from his paper once and said without preamble that the quiet ones always won in the end. They just had to be willing to wait. I had been willing. I set my coffee down on the arm of the chair and looked at the water and thought about what it meant to inherit something. Not the legal mechanics of it, not the document on page 11, but the deeper thing, the specific weight and responsibility of being handed something someone else built. Something they believed in you enough to protect with 11 years of careful planning and a sealed envelope and a notary on Tremont Street who kept faith with a promise made to a man who could no longer keep it himself. It did not feel like winning. It felt like a beginning. The house was mine. The company was mine. The morning was mine. And I had not taken any of it. I had simply been patient enough and careful enough and quiet enough to receive what had always been meant for me. There are people in your life who will look at what you have and decide it should be theirs. They will use the language of fairness and family and practicality, and they will be so practiced at it that sometimes you will almost believe them. What I learned is this: you do not have to argue with them. You do not have to perform your worth for rooms that have already decided not to see it. You simply have to know what is true, document it carefully, and wait for the moment when the truth becomes undeniable. The moment always comes. If there is someone in your life who has taken something from you, your voice, your place, your inheritance of whatever kind, I want you to know that patience is not the same as surrender, silence is not the same as acceptance. And building something quietly, in the background, with the long view in mind, is not weakness. It is the most powerful thing I know. If this story stayed with you, leave a comment below and tell me. Have you ever been underestimated by the people who were supposed to know you best? I read everyone. Hit like if you believe in quiet strength, and subscribe if you want more stories like this one. I'll see you in the next chapter.